Yes, yes.
Okay.
This is Shirley Fessler. I'm the Rural Sexual Assault Project Manager at the Kansas Coalition Against Sexual and Domestic Violence. And I just want to thank everyone for joining us for the webinar, and I want to thank our presenters, and I want to thank NUAP, the National Immigrant Women's Advocacy Project, for coordinating this and putting this on. And I'll turn it over to Leslie and the presenters.
Wonderful. Welcome, everyone. Thank you for joining us today. This session is being recorded so that it can be viewed later by law enforcement officers and prosecutors and other certifiers in Kansas. And I want to thank the Kansas Coalition for their leadership in starting in initiating this webinar series. This webinar event was sponsored by supported by the Office on Violence Against Women. The opinions are those of us that are training and not necessarily reflect the views of the Department of Justice. So my name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law, and I will be one of the presenters today, together with Shelley.
Yes, I'm Shelley Sonnenberg, and I work with the Boise Police Department in Boise, Idaho. I'm currently assigned to investigations, but I spent 5 years as the refugee and immigrant liaison for the department.
Michael?
Yes, hello everyone. This is Michael LaRiviere. I am an investigator with the Salem, Massachusetts Police Department. I've been here for 30 years, and I'm currently working as a victim services officer with a lot of work on domestic violence and immigrant populations.
So the learning Mike, off to you.
Yes. All right, so today the learning objectives we have, we want to have everybody at the end of this workshop to enhance their skills working with immigrant victims of domestic violence, sexual assault, stalking, and human trafficking. We're going to hopefully provide some tools to help hold offenders accountable using the certification process as it was intended as a crime-fighting tool, and then recognize and understand the benefits of UNT visa certifications for victims.
So we're going to start with some information, just some demographic information generally about Kansas. And what I find interested in talking about this is that oftentimes every time we do the demographics for a state, there's always some interesting surprises. So here, about 7% of the state's 3 million people are foreign-born. 39, almost 40% of the foreign-born residents of the state of Kansas are naturalized citizens. About 30% are undocumented, and another 30% are people who are lawful permanent residents or in temporary status. And the reason I mention the temporary status people is it's really important to understand is we're going to be talking a lot about crime victim visas, VAWA self-petitions, U visas, T visas here today. And it's important to understand that those visas are available to help any foreign-born crime victim in the state who is not a U.S. citizen, a naturalized citizen, or a lawful permanent resident. So it's not limited to helping undocumented victims, but also helps documented immigrants who might be here on work visas or student visas or something like that. Kansas has seen a 52% rise in its immigrant population in the decade and a half between 2000 and 2016. 16% of the children in the state of Kansas who are under the age of 18 have one or more immigrant parents, which is a lot of households, and about almost 90% of the children living in those households are U.S. citizens. The immigrant population in Kansas includes a lot of Latinos, with Mexicans being the largest group of immigrants in the state. But the state also has a fairly significant number of Asian immigrants from Vietnam, India, and China in particular, and also has 7% of the immigrant population are European, and 3.7% are African. Many of those Africans may be refugees, for example. It's also important to understand that the limited English proficiency rates are also important. Naturalized citizens, foreign-born naturalized citizens in Kansas, 37.6% of them are limited English proficient, and among non-citizens, the limited English proficiency rate is 63% for the state. Back to you, Mike.
Yes, so it's important for us to recognize the benefits to understanding and utilizing these relief benefits. And the ones that we want to make sure we point out is the increase in reporting. You're going to have a situation now where you're going to have undocumented crime victims who are going to be more comfortable reporting the crimes to us, which in the next step of that would improve our investigations by enhancing the participation of the victims throughout our investigation in the criminal process. And a big overreaching benefit of this is increased safety, and that safety isn't just for the victims themselves, although that is important, but it's also safety in the community in general, safety for us as law enforcement officers responding to these crimes and out there doing our duties in our community. So with that, before we get into the barriers and fears present in rural jurisdictions, in general, we want to talk about what some of the barriers and fears are that prevent immigrant victims of domestic and sexual violence from reporting crimes to us in law enforcement generally. And what we see and know in working with immigrant crime victims is they're very much afraid of being deported and being separated from their family, from their community unit that they've developed here. Also language. So as Leslie mentioned, language access being such an important piece of this. A lot of times they're LEP, limited English proficient, and they can't communicate with us, and that's a fear, and they're not sure how they're going to be heard and if they're going to get their point across in a way that we're going to understand what's going on. Isolation in general, and that's not, again, Shelley's going to talk a little bit more about the specifics with rural and how that adds to this, but in general, as an immigrant, as an undocumented victim of crime, they'd be isolated from being able to even reach out to us, not understanding their legal rights, even having knowledge about what would happen if they did go to the police. There's this big fear and lack of trust with the police and the prosecutors, the system in general. A lot of times victims are afraid to even come forward. They're afraid that we're going to contact DHS. We're going to, start the process with getting them removed from the country. So it's a big issue that really affects our ability not only to identify these crime victims in our community, but even in the situations where we do have access and we come across crime victims, having the ability to actually find out what's really going on and complete our investigation in a way that's going to hold these offenders accountable. So Shelley, you're going to talk a little bit more in depth about the rural aspect of this?
Yeah, so those are overall challenges when you're dealing with immigrant victims, but on top of that, when we move out into the more rural places, it becomes even more difficult for those victims to come forward. So we're going to talk about the unique barriers that exist within the rural jurisdictions that would impact these victims and their ability or inability to report the crimes. So some of them are going to look very similar to what Mike said. We're dealing with isolation, but one that is overlooked an awful lot is the transportation aspect of things, which kind of relates back to the isolation. So here in Boise, we have a bus system that runs pretty regularly. However, it doesn't run out to the outlying areas into the suburbs where a lot of these people live because of the cost of living around here. So just by not allowing them to get around isolates them, and it also makes it very difficult for them to reach out and contact others when they are in crisis and they need some help. In addition to that, we have the language access aspect of things, where in the rural communities you just oftentimes don't have the options or the resources to contact somebody who speaks a different language and assist them. So that makes us look at what options are out there to the officers that are responding to actually figure out what's going on when there's a language barrier. Obviously, with some of the groups that are coming in, there's an extreme difference in cultural beliefs and views and how the process is handled specifically within domestic violence. In many of these communities, domestic violence is dealt with at a family level, and law enforcement oftentimes aren't even notified about these things. So in our jurisdiction, we really tried to work on training the law enforcement officers to be more aware of the situation that they're walking into and recognize that there might be some issues along these lines, and try to offer some resources and help in different ways.
And if I can say something on that, Shelley, one of the things that we see when you work with immigrant victims from different cultures is that there'll be tactics that the perpetrator may use to that are very culturally or religious based, that an officer might not be thinking about because they might be different than the tactics that might be used by an abuser who's, let's say, born and raised here. And so knowing more about and having a connection with victim advocates who serve that community can be a very helpful tool for law enforcement to help them understand what some of the dynamics they might be seeing in some of these relationships.
Yeah, absolutely. And oftentimes the perpetrator is also the one who's causing the isolation and limiting that access to those resources. And when you have a language barrier on top of that, I think that that is multiplied. So there is quite the struggle for us to try to reach those victims and get them the help that they need.
And that's where I think knowing kind of who are the victim advocacy programs can be really helpful, because those victim advocacy programs, you know, oftentimes perpetrators, particularly in rural communities where there are not a lot of resources, and particularly of immigrant women who don't speak English or Spanish, are going to use control over language as an isolating factor. And one of the big roles victim advocates can play, and I had lots of clients like this even in a larger urban area, where, you know, they hear the language all the time, but part of the power and control is they can't speak, they're not allowed to speak it, English. And so sometimes getting them into an ESL class or getting them into a place where they begin, you know, they can feel safe trying to speak Spanish or giving on that they understand it can really, it's one of the roles victim advocates can play in helping these victims, and often do.
Yeah, absolutely. And once you get somebody like that involved, I think getting the language access, although transportation is difficult, you have a lot of people in the community that are willing to go out and assist in those areas where they can go out and help with English language classes, maybe responding to that location rather than having the victims come into the city or come into an area where the transportation is difficult. So luckily we do have some things that we can offer the victims to maybe make them a little safer and feel more comfortable coming forward. And two of those that we're going to talk about today are the U&T visas, which basically allows law enforcement to reach out to a community and find out really what's going on. You know, Mike talks about the importance of knowing what's going on in the community and the benefits of the U visa and the T visa. If we don't know what crimes are being committed, it's really difficult for us to make our city safe. So these are resources for the victims that actually end up really helping law enforcement out and benefiting us. So there is a certification that they have to go through. We'll talk in depth about that. That doesn't mean that they automatically become citizens. And I think with law enforcement officers, sometimes the difficulty is thinking that I'm going to sign off and I'm saying that I'm standing up for this person when I don't know them at all. It's not the point of the U visa or the T visa at all. It gives us the ability to actually go after the offenders and make a case and get them off the street so they're not hurting anybody else. These are people that target the immigrant and refugee populations simply because they're a vulnerable group of people. So it's important to understand that with these processes that at any time. It can be revoked if something doesn't fall into place. So just if you do sign a certification, it doesn't mean that it's, you can't go back and say, I don't believe that this person is assisting, or if a situation has changed. There's always a process in place that allows us to make sure that the U visa is being certified and the victim has maintained and done what they have are required to do. So just be aware that this allows us as a law enforcement community to make our city safe, which is what we signed up to do.
Yes, and Congress enacted the VAWA self-petition, which Leslie's going to overview in just a couple of minutes, and the UNT visas in 2000, with the purpose of doing some things. And one thing would be improving community policing and the community relationships, increasing prosecution of perpetrators who prey on immigrant victims, allowing victims to actually come to us and report crimes without fear of worrying about that we're going to contact anybody. They're going to be deported because they come forward and they're undocumented. And the last couple of things that were a really important piece of this relief when it was put together is enhancing victim safety and keeping communities safe. So I think it's just really that those things demonstrate, the reasons why it should be important to us in law enforcement to put things in place that can make this process and this relief a smooth thing for undocumented victims of crime in our communities, and something that they can feel comfortable reaching for and looking for assistance with as these reports come forward, I guess. And we do have a chart, a really nice overview chart that talks about the different protections that are available for immigrant crime victims. And Leslie's going to spend a couple of minutes now going through each and every one of those pieces of that graph coming up here.
So this is we call it the shield. It's a infographic that the Department of Homeland Security developed to inform law enforcement officers and prosecutors and victim advocates and individuals who qualify for immigration relief about the forms of relief available. And I'll talk about them in more detail, but it's a very good guide that you could keep in your squad car, keep available at your desk to just quickly help you sort, identify people who might qualify for one of these forms of immigration relief. The major forms of immigration relief that crime victims are eligible for on this slide, first thing I want to just say is the VAWA self-petition is a form of relief. Sometimes you will encounter a family, probably actually often you will encounter a family, and particularly in rural communities, where you have a U.S. citizen married to somebody who's foreign-born. And in those cases, when you have a U.S. citizen or a lawful permanent resident and they are abusing their spouse or child, or in the case of an over 21-year-old son or daughter, their parent, those cases will often be what's called VAWA self-petitions. So they're a form of immigration relief that they can get. They don't need a certification like we do with the U visa, but it covers domestic violence, child abuse, and elder abuse within families where there's like a marital relationship or a parent-child relationship. So some of the people you encounter will have this form of immigration relief, which is it's a much shorter wait to get the relief and much easier to file for, much less complex process than the U visa. The U visa we'll be talking about in detail. We'll also be talking about T visas very briefly for trafficking victims. And then around in areas like where there's universities, for example, you may have professors, for example, who are on work visas. Their spouses, if that spouse is abused, can qualify for work authorization based on the domestic violence prior to filing for a U visa. And then there's also children you may encounter any child who's been abused, abandoned, or neglected by one of their parents could qualify for a form of relief called special immigrant juvenile status, which the advantage there too is that it has a shorter wait time and a quicker processing time like VAWA self-petitioning does than the U visa. One of the reasons it's so important and that we have tools available for law enforcement and prosecutors, in addition to the shield I showed you, tools that will help you quickly identify victims who qualify for immigration relief. And it's really important to identify these cases as soon as possible, because we know from social science research that perpetrators of violence against immigrants are actively involved in trying to trigger, so that victims don't cooperate with police and don't cooperate with prosecutors. They often will try to turn them in for immigration enforcement with immigration officials. And screening early, identifying cases early, and helping them get their, getting them to a victim advocate or an attorney that has expertise in working with immigrant survivors helps identify these cases early so that the victims file a case, and once their case is filed, it gets put into a computerized red flag system within the Department of Homeland Security that helps prevent your fellow law enforcement officers working for the Department of Homeland Security from being tricked by domestic violence perpetrators, sexual assault perpetrators, traffickers, into trying to remove the victim that you might be trying to work with. So it's really important to try to file these cases early. The other reason it's important is there's a brand new January 2018 ICE courthouse enforcement policy that limits the ability of immigration enforcement officials to do enforcement activities at courthouses. If they're going to a courthouse, it will have to be generally in a criminal case, and they need to be going after a particularly targeted individual, which is people like, who have criminal convictions, people in gangs, national security, people who might be public safety risks, or people who have outstanding orders of removal. They have agreed that they're not going to be targeting or talking to, if they're going after a particular target in a courthouse, they're not going to be talking to witnesses or other people accompanying that person to court. And very importantly, they're going to not be looking to talk for immigration enforcement purposes with victims and witnesses, and they're not allowed to go to a family court or any other kind of non-criminal case, let's say like a protection order proceeding, without getting approval at the highest level of the DHS field officer. So essentially the field director or the special agent in charge needs to approve any enforcement action occurring at a family court or a civil court, and that we should see that those are more and more avoided in the future. But by certifying early and by telling people about the forms of immigration relief and screening early, law enforcement officers and prosecutors can essentially join DHS officials in helping make sure DHS officials have the information they need so that they're not essentially sicked by the perpetrator on the victim.
Okay, so what are the requirements for obtaining the U visa? Number one, you have to be a victim of a qualifying criminal activity, and Shelley's going to go through those in just a second. Also, you have to have been, are being, or are likely to be helpful in the detection, investigation, prosecution, conviction, or the sentencing of that criminal activity. That's not all of the above. That's, and or. So it could be just one or just a couple of those areas. You have to have suffered substantial physical and mental abuse as a result of the victimization, and you also have to possess information about the crime which has to have occurred in the U.S. or violated U.S. law. One just important thing I wanted to note about these requirements when you look at these, the part that talks about suffered substantial physical and mental abuse as a result of the victimization, that's not something that we utilize to determine as certifies whether or not we're going to certify under that criminal activity. But that doesn't mean that we shouldn't pay attention to it, because there is some really good things that as law enforcement officers and investigators we can provide to the victim, which ultimately goes to DHS, that will help them make that determination. So things such as like injury, photographs, any kind of evidence, details and reports that talk about the abuse that occurred, if it's that type of crime, and what injuries actually happen as a result of that. Shelley. That's Leslie, actually.
Oh. That most of the crimes that the U visa covers 75% of them nationally are domestic violence, sexual assault, human trafficking, with felonious assault and kidnapping being other significant forms of crimes covered.
So as we can see with the qualifying criminal activity, that there are numerous crimes that are included, but most of them are what we would consider violent crimes. So we've got domestic violence, murder, manslaughter, stalking, those type of things. So any of those are what would be considered a qualifying crime to consider. So who can apply? Anybody who meets the who is a victim of that qualifying criminal activity, the parents or guardians of which would be considered an indirect victim. So if the victim is under 21 years of age or incompetent or incapacitated or even deceased. Occasionally, not very often, the bystander victimization can be considered, but that is a very limited situation, as well as the next friend, a child's next friend, which would be considered somebody who's representing the child or the person who has the disability.
And to give you a picture just for a second of the bystanders, the bystander is going to have to prove substantial harm as a result of the criminal activity. So if you think about if there's a shooting at a birthday party of a child, and one of the attendees was pregnant and was so scared, she wasn't actually hit with any bullets, she might not have been the target, but she miscarried as a result of being present at the crime, that's an example of when a bystander might qualify.
Thank you. So who can certify? Ultimately, from the federal, state, and local level, that's going to be your police and sheriff's office, your prosecutors, your judges. However, in many cases, and I think Mike in his organization, it falls on him, the sheriff or the police chief can also appoint somebody to certify. So in my case, my chief is the one who does the certification because he feels like he's got a better pulse or finger on the pulse of what's going on in the community. But in an agency as big as Mike's, that's probably pretty impossible for somebody like that to be looking through all of those. As you can see, there's many other agencies that are also able to certify, but I will say, at least in my area, it usually does come through the police department.
So basically, when you look at what to consider, you're thinking about what criminal activity happened, what occurred. You need to know who the victim is or the indirect victim who may be looking to, request this relief and be a part of that 918B certification form. We're spending a lot of time paying attention to the helpfulness, determining if the person that's requesting this relief has been helpful in one of those areas that I mentioned earlier. And we're going to get a little bit more in depth about helpfulness in just a few minutes. And then we're going to take a look and determine whether or not any family members were implicated in the crime. And that's important information to pass on to DHS. So in short, the questions you're asking, do I believe this person was a victim of a qualifying criminal activity? Did this person assist, or are they willing to assist in the detecting, the investigation, the conviction, the prosecution, and or the sentencing of that case? What we don't want to get involved in is asking questions like, can we get a prosecution in this case? Can I arrest the person for what they did? Is this a situation where I have proof beyond a reasonable doubt? Will the prosecutor's office go forward with this case if I continue on? What's the statute of limitations on this relief, and did we get a conviction? None of those things matter at all. We're really, in our role as certifying officials, we're really just looking to make sure that person meets those requirements I mentioned earlier. And if they did so, anything we can to help support that, we want to share and sign off on that certification. And the real hard work, the heavy lifting, happens in the next steps where the person is requesting a relief, hopefully with the assistance of their immigration attorney, puts together a large packet of information that goes to DHS, and they conduct their thorough investigation and determine whether or not to actually issue that relief. So although a very important piece of this process, it's a small piece when you think about what really has to happen to get to the point where the person gets issued this relief.
And it's for that reason when the Department of Homeland Security wrote the wrote the regulations that what they did was they were trying to encourage people to come forward as soon as possible. The idea is for law enforcement to encourage people to come forward and give law enforcement tips about information, being willing to go get the rape kit, being willing to talk to the officer. So when the statute was written, when we wrote it, there was no degree of helpfulness required because the idea was, the hope was that you would encourage people to come forward and that they would continue coming forward over time, which is in fact what the research data tells us about both VAWA self-petitioners and U visas, that once they come forward and start filing their immigration case, over time they do, and particularly as their immigration case proceeds along its course, they become more and more likely to call and be working with law enforcement. And then it's important to note that you can complete the certification as soon as you identify one form of helpfulness. There's this ongoing cooperation requirement in the regs as well, and we'll talk about more of that in a little bit. And the investigation or prosecution can still be ongoing. It doesn't have to be completed, and it doesn't have to have necessarily been initiated at any given time. Mike?
Yes, and there's a lot of things that we hear as we deliver the training such as this around the country of reasons why maybe folks don't certify, or things they think maybe takes away from their ability to be able to certify. And we just wanted to make sure everybody understands you can still be determined helpful. Helpfulness can still be satisfied if the person reports a crime that's never been investigated or isn't going to require any more investigation. If it's something that the perpetrator isn't around or is subject to immigration removal, it's very victim-based. The perpetrator is maybe being prosecuted for something else, or the victim's not needed as a witness in the criminal activity. If the victim's dead, as you saw when Shelley went over the qualifying criminal activities, you do have a situation there where, it could be a situation where the person is actually dead, and now you have the indirect victim who's going to be a part of this this U visa process. And again, I think when Shelley went over those crimes, just another point to point out, when you look at that list, we're not talking about crimes that would be misdemeanor in nature, like our larcenies and those types of things. We're talking about some of the most serious crimes that can occur in the community, and that's why it really should be important for us to do a good job with this and make this relief possible. So if the victim has a criminal history, or if they're themselves subject to some form of immigration enforcement, that shouldn't affect our process, our ability to actually sign off on a visa certification. And statute of limitations is another one that comes up a lot. It's like, oh, this happened like 7, 8 years ago, and now they're coming forward now. Well, it's very normal for them not to even understand that this relief is even available, but then all of a sudden find out about it. And the DHS, the regulations have no statute of limitations whatsoever. So it would be totally appropriate that if somebody came forward and reported a crime that happened 7, 10 years ago, as long as you believe that this person was a victim of that crime and that they were helpful, or they're going to be helpful if more information comes forward, it's okay to sign off on that. Just remember that DHS are the ones that are going to have to really do the work to investigate this request and decide whether or not they're going to award this relief.
And in fact, when the statute was written, it was understood. I mean, part of the reason you want people of some of those earlier crimes to come forward is if they are actually making reports, and let's say 6 months from now another case happens and it's similar, you actually might be able to establish a pattern with a perpetrator in your community that you wouldn't have known. The first one you would have seen might have been 6 months later, and you don't even think that it's necessarily part of a pattern. But by those older reports coming in, you can see the whole history, and it will help you hold offenders accountable you might not have been able to otherwise.
Yeah, so why would an immigrant victim report sexual assault or domestic violence and then refuse to participate in the investigation or the trial? Well, if we think about this, I mean, even with domestic violence victims, oftentimes they come forward and they end up changing their mind, and they don't have all the other baggage that comes along with the fear of deportation, the language access issues, and we see that on a daily basis happening within the community. So if it's scary for them, and then you add on all the other barriers that are put in the way for the immigrant victims, then to me it really does make sense as to why somebody often changes their mind. It's not just the fear of retaliation, but oftentimes there's pressure from the family. Again, just like with domestic violence victims that are citizens here, oftentimes the perpetrator is the main breadwinner for the family. It's no different within the immigrant communities. They're not able to maintain regular contact or have support with anybody, and oftentimes they're worried about their children. So some of the same reasons that we see in our day-to-day life with many of the victims that come forward and change their mind, it's just really emphasized when you add the struggles that the immigrant victims are dealing with.
So immigrant victim, in these U-Visa cases, what happens is there'll be times, as Shelley was talking about, where the victim will start cooperating and then she'll get a threat, or he'll hold her hostage, or he'll threaten to harm her children or something, and she becomes afraid to go forward. We see this routinely in domestic violence and sexual assault cases, and again, that's a large part of the cases that U-Visa covers. And so it's important what the U-Visa program does is it recognizes that there may be times where it's that you can make a reasonable request as a law enforcement officer, but the victim's failure to refusal to cooperate isn't unreasonable under the circumstances. And so what happens is if in fact she came forward and has been helpful and you signed a certification, and then later on maybe there's a period of time where she's not cooperating, the question is in evaluating whether or not that non-cooperation, given the totality of the circumstances, which is the standard that DHS will use when they look at this, is they'll look at the nature of the victimization, the totality of the circumstances, the victim's fear of the abuser. They'll look at how the crime impacted the victim, the trauma that she'd suffered, and to what extent her her more limited cooperation or refusal to continue to cooperation is affected by force, fraud, or coercion that the perpetrator is using to manipulate her. And so, there's an ongoing obligation. What's important to understand is that we understood when we wrote the statute that crime victims kind of go back and forth. There's times where they feel stronger and they can cooperate and times when they may not. So this non-cooperation issue is measured at different points in time. So a victim will get her U-Visa case waitlist approved, and then a few years later when she's ready to get her visa, they'll look at her cooperation again and say, did she continue to cooperate? And if she didn't, she'll have to prove that it wasn't unreasonable to get the visa. Then 3 years after that, when she gets lawful permanent resident, applies for lawful permanent residency, she again needs to prove either that she cooperated or any periods of non-cooperation were not unreasonable. And so that DHS, it's set up to check this at several points in the process, understanding that victims, the safety for them and their ability to cooperate changes over time. In a good way, actually, is what the research data talks about with U-Visas. Oops.
So ultimately, what I'll say is this happens very rarely. In my experience, I honestly can't think of one where I've actually had to fill out the certification and say that I didn't believe that at some point the victim wasn't assisting and being helpful. But if you get to the point where you just really believe that they are unreasonably refusing, you're able to note that on the certification, and then once it's signed, turn that back over to the victim or the victim's attorney, and they will take it from there. It ultimately becomes the victim's responsibility to prove that the refusal was not unreasonable. So they've got to have a lot of evidence to show that why they chose to either stop assisting or that they chose not to assist in the beginning. I'm going to say just please do consider all the reasons why we see people back out of a situation after they filed a report with us. And I guess as the final protector of all, the Department of Homeland Security makes the ultimate decision. They review things, they complete the background. They're the ones that are going to say that if there are problems and they can identify what those will be, they have the option of refusing it as well. So there are a lot of things in place that allows us to make sure that the victim that we're asking to keep here in the U.S. is here for the right reasons.
Mike, can you add a little bit about what you know about the background checks that USCIS does? Give them an idea of what it involves.
Yeah, we've been there several times at the Service Center, conducting some training and working together on getting the right information out there. And I'll tell you, the first time I was a part of that, I just totally 100% put all my trust and faith in the work that they do. I mean, they take their job seriously. They take the information we provide to them, and then that huge packet of information that the victim, through their immigration attorney and anyone else that's helping them put that together, the biometrics and showing their record and all those kinds of things that DHS will take a look at. They spend, the reason it takes so much time, they spend the appropriate time to actually look into this situation and to address any issues or maybe kind of, blank areas that might arise in that investigation to determine whether or not they're going to issue the release. So I think, I think what you're getting at, Leslie, which I 100% agree with, is the fact that, our role is really important, like I mentioned already, but we don't want to make our role something it's not. And as long as it fits the things that we've talked about, it's okay to sign off on that. If you have a little bit of issue, and I love the way that, Shelley, you said, like, if you're still not sure and you think that maybe it might not be a situation, where they're being fully cooperative, note that in that U-Visa certification form, and let DHS investigate that a little bit further. And the piggyback on that is another thing that Shelley said, that keep in mind why victims don't cooperate in general anyway with some of these crimes. And we saw the statistic that shows about half of these U-Visas are issued under the domestic violence and sexual assault criminal activity. I think about over the span of my 30 years doing this career in law enforcement and doing this work, how many hands it would take to count how many victims of domestic violence and sexual assault actually cooperated from the beginning throughout the entire process of conviction and sentencing. They don't, for a lot of really, really good reasons. And that doesn't change because they're undocumented. In fact, it actually magnifies and adds some additional barriers that we as a system and as folks who work trying to make a difference in these fields have to actually take the rein on that and try to make a difference and kind of bring that person where they feel comfortable coming forward and talking with us. So I'm not sure if that answered that fully, Leslie, but...
So, as I said earlier, that once you sign the certification, the victim includes it in her initial application. And Mike said the applications are, several inch thick documentation, affidavit, medical records, all kinds of information. Then once the initial application is processed and screened, it's put into this database I was talking about earlier, which is designed to try to help make sure that immigration enforcement proceedings are not triggered by the offender trying to turn the victim in. And so that's going to be helpful to law enforcement officers and prosecutors because it means the system is designed to help keep the victim around so that they can continue to cooperate and assist in criminal investigations and prosecutions.
And I know in the work that you've done, Leslie, and some of the studies that you've done around this, it's been shown that they actually do cooperate more frequently when this process is happening, and they're more likely to participate throughout this entire investigation and criminal process, correct?
Right, exactly. The number, I think, is 70% of U-Visa victims actually do cooperate over time in the case. They start and then they may stop, but then they ultimately, as they get more confidence because they are protected from deportation and they're less fearful, they're more likely to cooperate. And in fact, we see them reporting future crimes, and that the almost 30%, I think it's 29%, who are not included in the 70%, those are cases a lot of times where they want to cooperate, but the perpetrator is absconded and they haven't been able to serve the warrant on him, or for some other reason the case isn't going forward. He's fled the country, or he's in jail, or he's been deported, or something like that. So that there are very high over time, this U-Visa program is very successful in ultimately encouraging more and more immigrant crime victims to both cooperate in the initial case and come forward and report other crimes. In fact, there was a case, Mike, we have a few minutes. Do you want to talk about the case that occurred in the metropolitan area near D.C.?
Yeah, well, we were conducting a training, a full-day training on U&T visas and the certification process, and we had one of the participants that was, sitting in the room, wasn't necessarily the most vocal participant throughout the process of the training, and then towards the end of the day, got up and, made it clear that he wanted to make a statement, and of course everybody's at the front of the room wondering what's going to happen here, and, what's going to be said, holding your breath, and InShot, he basically provided a story, a situation that he was involved in where he and his partner, they were gang unit officers, and they had infiltrated one of the most violent gangs in that community. And they were running guns, drugs, and committing all the horrible crimes that you can think of that one of these gangs could do. At the same time, unbeknownst to them, the gang leader's girlfriend, who was also, being tossed around the gang and being, victimized in a variety of ways by the gang members, she had reached out and had been involved in an investigation with that same agency's domestic violence unit. And due to the trust that was built, and they had started the process with the 918B certification, and were assisting her with that, and with the trust that was gained, she disclosed to them that she had heard that they knew that these two gang unit members were actually police officers, and they were planning to hit them. They were planning to murder them. And if it was not for the fact that, the domestic violence unit was doing the things that they do and, opening up the doors for immigrant crime victims in their community, these two gang members likely would have been murdered in short note as a result of the information that the gang members had on them. So, and that's one of several. We've heard stories similar to this, maybe not as big as an impactful story as that, but where we've taken some real violent criminals off the streets as a result of this. And we had a situation in my jurisdiction when Liz was talking, I thought about it, where we had one victim of crime we were working with who was undocumented. As a result of that relationship and investigation, we had several others that came forward to report that they were victimized as well. So the benefits just continue to come forward as you work and on really opening the doors for undocumented victims of crime in your community. So how do you get those certification requests is the next thing that we need to talk about. And the most common way that we see these certification requests coming forward to certified officials is from either a victim advocate or an immigration attorney that's working with that victim of crime. You could also, as a police officer, being aware of and being knowledgeable about this relief, you could identify somebody as you're investigating, as you're responding, even as a frontline officer, identify this person. And certainly you wouldn't say, hey, talk to me because I have relief for you, but it would be appropriate when you have someone on scene making comments that they're concerned, I'm worried my immigration, I'm worried about deportation, that you could say, hey, I don't care about your status here. I care about what happened to you. And as far as your status goes, I'll put you in touch with somebody who may be able to assist you with that. And there may be some resources available to you. Totally appropriate to do something like that. Also, as a prosecutor, as an investigating officer, I think about my situation. I do a ton of follow-up investigations. So patrol would go out. They interact with domestic violence, sexual assault victims who make reports in the community. And I get those reports in a very short period after that. And I make phone calls and I touch base. I go to houses. And that's when I have an opportunity to utilize some of the training experience I have to maybe give that person an opportunity to talk about this situation. So I may identify them just doing that, similar to a prosecutor who was working on a case over a period of weeks or months.
So the U-Visa, the certification signing is the first step. The victim files the application, and in about 36 months, she gets an initial determination by the Department of Homeland Security, which is called waitlist approval. And at that point, she gets legal work authorization, formal protection, more protection from deportation than she has by filing, etc. Each year Mike?
Yes, so DHS is going to make their decision. They're going to decide if the person was a victim of a qualifying criminal activity. They're going to take a look at all the information that was provided and make a decision on whether or not they suffered substantial harm as a result of being a victim of that crime. They're going to look into the helpfulness piece way deeper than we would as certifying officials and make a determination whether or not they were helpful. And if they weren't helpful, was it reasonable? Was there reasonable reasons why they weren't helpful throughout this entire process, or was it unreasonable? And then they'll look at whether or not the victim is admissible. So they're going to take a look at the criminal history. They're going to look at the immigration history, that type of thing.
And so there are 10,000 visas annually. There's more people in line for a visa than there are visas right now, but that doesn't mean this process shouldn't go forward, because people, as I said earlier, get some protection from deportation upon filing. At 3 years, they get a formal, something called deferred action, which prevents their deportation. They get legal work authorization. Then ultimately when they get their visa, it's a temporary 4-year visa, and some victims will be eligible to apply for lawful permanent residency. And in order to apply for lawful permanent residency, they have to show not only cooperation, or that they didn't unreasonably refuse to cooperate, but also have to show humanitarian need, public interest, or family unity. And then ultimately, if they get lawful permanent residency, they'll be on a path to citizenship. So that throughout this process, as I mentioned earlier, there are background checks, and the ongoing cooperation issues come up. So there's lots of checks and balances in the system. So we're now going to turn very briefly so we talked about the U visa as a form of immigration relief, and you may have noticed that human trafficking victims get protection under the U visa. They also get protection if they're a victim of what's called a severe form of human trafficking. They get protection under another visa called the T visa that law enforcement and prosecutors can also sign a certification. In the U visa context, it's required. In the T visa context, it's very helpful evidence to a victim, but not a prerequisite to filing, which is why law enforcement officers see fewer requests of these, but your agency can initiate these just like you would a U visa. And that the elements of a severe form of human trafficking is you have to show there was a process, recruitment, harboring, or obtaining a person by a means, which is force, fraud, or coercion, and then the end is for the purpose of involuntary servitude, debt, bondage, slavery, or sex trade. The force, fraud, the force, fraud, or coercion, and the purpose pieces, this element apply to adult victims of human trafficking. Children under the age of 18 who are trafficked have a much less severe burden. To get a T visa, you have to be a victim of severe form of human trafficking in the U.S. or territories, or on account of trafficking, which means the trafficker has either brought you into the country or curtailed your movement once here. So you think of people held hostage in workplace environments, for example, or where their passports are taken and things like that. Prosecution, they have to cooperate in the prosecution, collaborate unless they're under 18 years old. There's no collaboration requirement for children. And they have to show that there'd be extreme and unusual hardship if they return to their home country. This too leads for a path to lawful permanent residency and ultimately citizenship. The federal definition of human trafficking is sex trafficking, in which the commercial act of sex is induced by force, fraud, or coercion, unless the person who performs the act is under the age of 18. And labor trafficking, again, it was kind of what I explained earlier, the harboring, recruitment, transportation, or provision or obtaining of a person for labor of services through force, fraud, or coercion. And then the process for human trafficking is to identify the individual, to get an endorsement or continued presence. There's a form of immigration relief that law enforcement officials can request that the federal government provide a witness in a human trafficking case. They apply and then they get a decision by DHS. This is a much faster process. It's not a period of years, it's a period of months for T visas. Shelley?
Okay, so how does law enforcement and prosecution benefit from the UNT visa? We've already hit on many of those, but just to go over one more time. Obviously, we're finding out that the crimes are occurring within our community, which is of utmost importance for law enforcement. It improves the investigations. We're getting more convictions because of it. It also is a great, and Mike already said this, but when you talk about community policing, not only is it you're identifying the stakeholders within the community, but you're working better together as a team. That's going to result in officer safety when we're responding to calls. It's also going to cut down on the number of calls that we're going to because we'll be able to identify the suspects in a much quicker and more effective manner.
And another point, the final point I want to talk about on this webinar is that we often hear from prosecutors, and we actually have a whole online video on the training video that we did with Jane Anderson from Equitas on this, that they're concerned about certifying early because they're worried that the perpetrator's counsel, defense counsel, will raise the issue and use it to undermine the criminal case. What we're finding is that with training, and again, we have great training tools for prosecutors on this, that prosecutors are being very effective is once the perpetrator raises this question about she's only talking about this to get a visa, most of these cases when the victim calls for help, and this is particularly true in rural communities, they're not calling for help because they know about a U visa, they're calling for help because they need help. And that a prosecutor can put together a timeline and bring in and show that she knew nothing about the U visa when she called for help or when she talked to Mike in a follow-up investigation. And prosecutors have been very effective in bringing in prior consistent statements and ultimately winning the criminal cases when the perpetrator's defense counsel raises these issues. So it's not something to be afraid of. We have lots of training tools for police and for prosecutors on these, and including a very good webinar just on this issue and prosecution strategies. So,
well, Leslie, that's a good segue into the technical assistance that NUAP provides. I mean, I know we've reached out to NUAP for that in my jurisdiction for some assistance. You have webinars that happen every couple of months. There's all kinds of documentation and publications that are on the NUAP web library that you can access through nuaplibrary.wcl.american.edu. Technical assistance peer-to-peer, I think, is a really great thing that NUAP provides, that if you're a law enforcement officer and you have a case that you're not sure about, you're concerned about it, you're not sure about certifying, you're having some issues in and around that, you could contact NUAP through their technical assistance provider phone number or email, and someone like Shelley or myself or anybody else that's on the staff, we have prosecutors, we have advocates, we have law enforcement officers that could reach out and work one-on-one with you, your agency, and your jurisdiction, trying to overcome some of the barriers or put in place some things that can be helpful to you in doing this work. I don't know if you want to get into any more detail about that, Leslie, but there's just so much available, and this is so intimidating, especially if you haven't really heard much about it and it's fairly new to you, to think about how am I going to do this right. And, you know, we haven't spent a lot of time talking about language access, but they go hand in hand. A good majority of the people that are going to reach out looking for this relief and looking for help from us are going to be LEP. And it's important to have those good language access policies in place and have good resources so you can do it in a meaningful way, in a way that actually complies with Title VI.
And I
think that coming from a rural aspect of things, that language access is so important when you have such limited resources. So I would really encourage everyone to tune in when we do present that, which I believe is our next webinar.
Yes. And also we offer a peer-to-peer opportunity through a roundtable that if you're interested, you can send an email to info@nuap.org or nuap@wcl.american.edu, and we will connect you and let you know about information about not only the upcoming webinar that we're offering here, but the upcoming every other month roundtables we have with law enforcement. Thank you, Kansas Coalition and the Kansas Law Enforcement Training Center for sponsoring this event, and thank you all for attending.
Thank you, Leslie, Mike, and Shelley.
Thanks. Take care, everyone.
Take care.
Thank you.